Good afternoon. Welcome to the Long Live Third Parties podcast. Free Press Media Press, Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Richard. Today I read the case Libertarian Party of Arkansas v. Martin, 876 F3D 948, Court of Appeals, 8th Circuit, 2017. Friends, today we're going to talk about a certain political party. One that keeps popping up in these cases. Guess. If you guessed the Libertarian Party, you guessed right. Way to go. Bravo. I like this case. You want to know why? Let's read from the record. The Libertarian Party of Arkansas, Christian Vaughn, Robert Chris Hayes, Deborah Standiford, and Michael Pacquiao, collectively Libertarian Party, brought a declaratory judgment and injunctive relief action against the Arkansas Secretary of State, claiming that the ballot access statutory scheme violated the First and 14th Amendments. The scheme required new political parties to hold a nominating convention prior to the major parties' preferential primary election. The district court granted declaratory relief, denied injunctive relief, denied the Secretary of State's motion to reconsider, and awarded costs and attorney fees to the Libertarian Party. The Secretary of State appealed, and during the pendency of the appeal, the Arkansas General Assembly amended its statute to allow new political parties to hold their nominating convention and submit their certificates of nomination at 12 p.m. on the day of the major party's primary election. End quote. Hear all that, friends? I heard a lot of wins for the Libertarian Party. Again, they're invoking the First and 14th Amendment. Way to go invoking those awesome amendments. Like we like to mention on this podcast, I see that again and again, and we love the First Amendment. And the 14th Amendment, we're fond of that too. In this situation, it sounds like the district court found their invoking of the First and 14th Amendments to be valid. In many of these cases where our third-party friends invoke the First and 14th Amendments, if not the vast majority of them, the courts deem it invalid. So this is good. Declaratory relief, injunctive relief, those are legal terms. So maybe someday we'll look them up. You hear that? They changed the law. The Arkansas General Assembly changed the law to make it more equitable for third parties. I wonder what prompted them to do that. I wonder why they did that. I wonder why they would put aside the duopoly in order to do this. Whatever the reason, we cheer. Say hooray with me. Hooray! Our friends at the Libertarian Party got cost and attorney fees. I've seen that mentioned in some cases. But most of the time, even when we do win, we don't get those fees. So that was awesome. Now, because the Secretary of State appealed, we need to find out what happened with this at the Court of Appeals level. So did the Court of Appeals here find the district court's ruling valid? Another issue that comes up in this trial, the Libertarian Party mentions that it's possible for the state to change their laws, so they want them to address this. But the court is saying this is mostly a moot issue because they did change it. However, the issue of it being moot alone does not mean our friends are not going to win this case at the Court of Appeals level. The Libertarian Party makes some additional arguments. Let's hear what they say. It says, quote, further, it contends that by requiring new political parties to hold a nominating convention before the preferential primary election, the statute gives Republicans and Democrats the advantage of learning the identities of minor political party candidates, thus allowing them to select their candidates accordingly. Finally, it argues that the previously existing requirements could be reenacted, resulting in a problem that might well again evade review. End quote. Like I said earlier, the court here is arguing that this is probably not going to come up again. So maybe you think it does. So we can consider that. That's an interesting argument they're making about how the timing of the convention puts the Libertarians at a disadvantage, not just because they have to work faster to get it done, but because it puts them on the defensive as they get to nominate their candidate, but then the other parties can wait and see how it affects their situation. That's something I would not have considered on my own. So I appreciate the thought that goes into this. They have a whole section in the case about awarding attorney fees, and as it relates to mootness too. Because although our friends in because the Libertarian Party won most of the points at the district court level, but not all of them, there's debate in this case about whether they were a prevailing party, as the legal term is. They do cite other cases where they determined that you don't have to win every single point to be deemed a prevailing party. So the Libertarian Party was deemed prevailing. As they say, quote, the Libertarian Party was the prevailing party in this case because the district court awarded it declaratory relief and deemed the statutory scheme unconstitutional, end quote. Yes, it's very clear to me they were the prevailing party for all intents and purposes. Not every point they won. It's hard to get 100% in everything you do. Even the best things in my life, my biggest victory is it's not 100%. I don't get every last thing. So the same goes for Libertarian Party in court. They won a big victory in that district court. They didn't win everything. So still, they are deemed the prevailing party. So ultimately, the court concludes as follows. It says, quote, the Libertarian Party obtained a material alteration in its legal relationship with the Secretary of State prior to the legislative action that rendered its lawsuit moot. It was not required to succeed on all its claims to be deemed the prevailing party, and so the district court acted within its discretion in awarding the Libertarian Party costs and attorney fees. The district court's order dated July 15, 2016 and judgment dated July 18, 2016 are vacated, and the case is remanded with direction to dismiss the complaint as moot. The district court's September 12, 2016 order awarding costs and attorney fees is affirmed. End quote. So this rocks, my friends. Not only did the Libertarian Party win at the district court level, they won at this Court of Appeals level. Now, they didn't get one of their points won, but the court affirmed what happened, that they would get their costs and fees returned. A lot of people say lawyer fees are extremely expensive. In fact, that's one reason I avoid lawyers myself. I find a way to do it myself. NOLO books encourage you to do as much as you can by yourself. So check NOLO out, friends, and you can see what you can learn. I can put the link of NOLO in the show notes. Also remember, friends, this is a victory because our friends got their fees and costs back. That means more money they have available to advance their party. And also they won the change of the law. Somehow it happened. I'm not sure what influenced the General Assembly to pass that law, but whatever it was, our friends won. So this is something to celebrate. Long live third parties. Goodbye.